All right, well, we will go ahead and get started. Thank you for those attending today's webinar, whether it's through the recording here on YouTube or online with us today. As you can see here, the purpose of the webinar today is we're going to be going over estate planning essentials. I know as we're about to all spend time together over Thanksgiving holidays, this is actually a really great time to update your estate plan. You're likely going to be around a lot of loved ones, hopefully so. And so we wanted to make this resource available to you all as we get closer to the holidays to maybe make some updates or maybe start anew with an estate plan for your family. If you've worked with Aspen before, one of our core beliefs as a firm is to do anything in our power to make our clients' lives easier, whether that's helping them lower their tax bills or planning for a vacation or even sitting them down and discussing their estate plan as we will today. Our job in its simplest form is to make our clients' lives easier. And an estate plan is a huge part of the financial planning process for a lot of our clients. So today we're going to go over a number of different topics. We're going to start with a brief explanation of estate planning and why we believe it's important. And then we're going to walk through the following main areas. We're going to talk about what goes into an estate plan. We're going to talk about what happens to your possessions or belongings after you pass away. We're going to discuss key components that go into an estate plan, such as beneficiary designations or the always encompassing, should I get a will or a trust, and other essential documents. We're also going to talk about some common mistakes to avoid that we see quite often with estate plans, and maybe some things you should consider if you have a unique family situation. And lastly, we'll discuss where to go from here, so when you leave this webinar, you have a plan in place. When we're done with those areas, we'll pause and take some time for questions, but please feel free to stop and use the chat feature along the way. My colleague Troy Four is on this call. He's going to be helping kind of moderate and facilitate that for us as well. So we'll go ahead, and what I want to do before we get started is just kind of get a framework or a mental framework around questions I want you guys to be considering as we go throughout this webinar today. And so the questions I've laid out here on the screen, I want you to kind of sit and chew on. And maybe you have answers to them already, maybe you don't. But I'm hoping throughout this presentation we'll address each of these questions and you can find them pertinent to you and your family. So questions to consider. Does everything go to your spouse or your loved ones? Do you have the right beneficiaries on all of your accounts? Maybe that old 401k at that old job or your current investment accounts or a retirement plan at work. If you're out of it, or incapacitated, who's going to call the shots for you or your loved ones? Who will take care of the kids? Would a trust or a will make more sense for you? And if you go that route, who should you name as your executor or your trustee? Maybe part of your estate plan, who knows where to find your records, both physical and online? I think a lot of people draft great estate plans and they kind of just sit in their office and they never actually get transmitted or handed over to their executor, which makes it very cumbersome if something were to happen to you. And lastly, have you considered how you could preserve maybe more money for your heirs through proper tax planning alongside your estate? So you may have answers to all those questions and you may not. But what we're hoping to do is before we get started, I want these kind of questions kind of mulling around in your mind. And we're going to go through a lot of these areas and we'll cover all these areas today. So if you sit tight, it should be all these should be addressed for you shortly. I like this quote kind of before you get started. If you fail to plan, you're planning to fail. And I also like this graphic. A lot of focus when they develop comprehensive plans, they're really excited to talk about their investment portfolios or their company or their cash flow or things like that. But estate plans are often kind of this lingering thing that sits outside the periphery of their to-do list and it just doesn't get done. And so I like this chart because a lot of people, what's top of mind for them is what's on their balance sheet, what's their cash flow, what are they making? But maybe it's not that lingering estate plan or the beneficiary audit from those old accounts. And so I think risk is looking at, knowing what you don't know and shedding light on those areas. One estate planning attorney, he told me that an estate plan is like a parachute. And if you find out that yours is faulty, it's likely that you're too late in the game to make any changes. And so we want to make sure our clients have really solid estate plans so that if anything were to happen, they're well covered well in advance. So what is an estate plan? What goes into an estate plan? What makes up an estate plan? An estate plan is a collection of documents that specifies how you want your money and your stuff distributed. It's a document that helps make your lives easier for your loved ones should, they be in a time of grief upon your passing. Okay. Estate plan, I kind of break it into these three different components. There's essentials in every estate plan that everyone should have. Beneficiaries on their accounts, a will, power of attorney, advance directives. Most folks, especially if you got young kids, might need life insurance. At Aspen, we are a fee-only firm, so we don't sell life insurance, but we certainly advise on it. We think it's an integral part of estate planning for a lot of young families. And then for some folks, you may need trust, whether it's a living trust or a testamentary trust or a revocable trust. You might have heard these terms before. Um, and some people need planning in that regard. On top of all these things, an estate plan can do a number of key components. They can help you identify someone you trust to make decisions if you can become incapacitated. An estate plan will specify who will care for your minor children if you're unable to do so. It can help minimize taxes and other wealth transfer techniques upon your passing. And it can help manage and plan for probate, which is the court supervised process used to value your estate or settle any debts or transfer assets to your heirs. Then the question becomes, who needs an estate plan? Well, you do. A misnomer is that a lot of folks think you need it only those who have wealth need an estate plan, but candidly, everyone should have an estate plan. If you're young and single, you may only need a few simple items, such as a will and beneficiaries or powers of attorney. If you have children, you'll need a will and maybe a guardian. If you've got sizable wealth or maybe a complicated family situation, you may need a trust or one or more trusts to help control how your assets are taxed or managed or distributed. And if you already have an estate plan, awesome. Just make sure you review it regularly and make updates as things, change. Life changes and life is dynamic. And so we firmly believe that financial plans and estate plans should be dynamic and fluid as well. So now we're going to talk about what happens to your stuff when you pass away. Um, it's and I know there's a lot of words on this screen, but I'm going to make it real simple for you. Your assets can go to one of a few camps. On the far left-hand side, they can go to another person. Maybe that's your spouse. If you own something jointly, normally it's like a house or a bank account. In the second column, we have things that go by beneficiary designation. So these are life insurance policies, retirement accounts, brokerage, or maybe investment accounts. The third bucket, maybe things you hold in trust. And so these are things that you've held in trust. Maybe you name certain assets in the name of a trust, and that's how they get distributed to avoid probate. But everything else goes through a legal process known as probate. And this is going to happen whether or not you have a will. But while having a will greatly helps the court understand your wishes, it does not override decisions you've made on things like beneficiary accounts or your established trust. So to kind of circle back on this slide, upon your passing, your assets will go somewhere. They can go to a loved one, whether it's a spouse or children. They can go to charity, churches and such. That's something else you can name as beneficiary. Or they can go to the state or through the probate system. It's ultimately your choice, and the way you dictate that decision, that choice, is by having an established estate plan in place. So what we're now going to do is we're going to talk about the lowest hanging fruit here. What's the easiest way you could wrap up this webinar or close out your screen now if you're watching on YouTube, and you could clean up your estate plan in a really quick minute? The first thing is by doing asset titling and beneficiary designations. Asset titling and beneficiary designations is one of the cleanest and simplest way to get your estate plan cleaned up. Okay. As you see here, asset titling is things like having a joint an account with your spouse that's maybe joint with rights of survivorship. It's going to pass outside of probate directly to the joint account owner. Okay, but there are also things can be like joint tenants in common, and that's maybe an account that you held with someone like a business partner or someone who's not your spouse. Asset titling is a way to essentially avoid the probate process. It's kind of like having a beneficiary on file, but my wife and I, for example, we have a joint with rights of survivorship brokerage account. If something were to happen to us, the account would either swing one way or the other till we both mutually own the account outright. Naming beneficiaries, another very simple thing to do that often gets forgotten about or at least updated along the way as their life changes. For assets like retirement accounts or insurance policies, you're asked to name your beneficiaries. But what about brokerage accounts, like joint accounts or bank accounts? Most folks don't think about bank accounts. And what do you do if you've established a trust? Who do you name a beneficiary then? Titles have specific legal meanings and typically take precedence over wills and trusts. Because your assets may have been titled years ago when you first opened an account or made a purchase, it's important to check and make sure that titling continues to reflect your life changes and decisions. Candidly, I'll tell you, I spent my first 5 or so years at Fidelity Investments. That was where I started my career. And I'll never forget the day I had a woman call in, and unfortunately, she had lost her husband. And so she had recently become a widow and was kind of in the probate process and just cleaning up her estate. And so she calls and she says, "Hey, my husband passed away." And she starts listing off the accounts. She goes, "I need to go through the process of getting this kind of reconciled and cleaned up with you guys." And on my side of the screen, taking the phone call, I could see that there was another account that she mentioned, but she wasn't named on. And so let's say there was 4 accounts. This woman was technically a beneficiary of 3 accounts. And so she goes to ask me about this fourth account, and we had to go through compliance stopgaps to make sure we could cover that information. But what it turned out was her late husband had, in another life, been married to a woman and named her the primary beneficiary of an old retirement account. And he never made a change to that. He never updated that account beneficiary. And from a legal standpoint, that account, that employer-sponsored 401(k) plan from a long time ago, was actually fair game for his ex-wife from 20 plus years ago to collect. They were able to kind of come to an understanding and make it work through the probate process, but nevertheless, it was an ordeal. And so that's something you just want to avoid if possible. Another thing to do is if you have multiple children as a beneficiary and you have a third kid, you go from each kid owning maybe 50-50 to 33, 33, and 33. Or jokingly, we say you got to pick a favorite. It's 33, 33, and 34 to make it clean. But nevertheless, it's really important as your life changes. That's a very easy way to get your estate plan cleaned up. I mentioned a comment here. One common strategy as well is if you do have a trust, and some couples do this technique where they name their spouse as the primary beneficiary, and their contingent beneficiary could be like their last will and testament of, or a revocable trust or something of that nature. There's different ways you can do it, but that way, if you ever make changes to your underlying trust or your estate plan, you don't have to then make changes to your brokerage accounts, which can be a very efficient way to manage your estate. So now we're going to talk about wills. The next key component of an estate plan that everyone should have is a will. This is perhaps the most important non-financial reason for creating a will is for parents to name a guardian for any minor children. And without a will, a state court can dictate who may become the guardian of that minor child. But a will, like we said, is probably the most commonly recognized estate planning tool and specifies how you want your assets distributed, including items of both financial and sentimental value. Okay. Beyond specifying how your assets should be distributed or who you name as a guardian, a will can also do things like name an executor of your estate, provide direction for how debts, taxes, and other costs should be paid, provide instructions for covering family members' living expenses during probate, and also designate the assets to be placed in a trust for loved ones. A will can do a lot of things. A key point here also for parents on this call or for grandparents with adult children, if you have young children, you need a will, period. A will is the legal instrument you can use to name guardians for your minor children. And without a will, the state will choose a guardian from among your relatives, and it may or may not be the person you would have chosen. Okay, so if you have a child, a minor child, if you have an adult child and you're a grandparent, so you have grandchildren, please, please, please make sure you get a will set up. The questions you hear on the screen are some that can help you decide how you want your will to be structured. Who should inherit assets? Who should care for your kids? How much is needed for their education? All these things can be spelled out in a will. But the counterpart to a will that a lot of people talk about is a trust. So what is a trust and how does it fit within the confines of an estate plan? A trust in its simplest form is a really basic concept. It's an arrangement whereby one person, we're going to call their legal term is the grantor, they're going to transfer money or property to a trust to be managed by another person, the trustee, on behalf of the beneficiary. And the primary differences between a trust and a will are three areas: control, probate avoidance, and protection for heirs. Okay, so we're going to stop there for a second and just kind of talk about each of these three differences. Some attorneys use this expression: a will gives you control from above the grave or above the ground, and a trust gives you control from below the ground. So a will, for example, when you pass away, can say what goes where and to who gets what. That's a will. Okay. A trust says it allows you to put control measures in place to say, hey, not only what goes where, but I'm gonna put a control in there to where, let's say I have three boys, so let's say I have minor children. I don't want them to have access to that money until they turn 25 or 30 years of age. They meet certain criteria. So you can kind of put some stipulations there and control over not only who receives the assets, but how they receive the assets, and if any requirements need to be met to satisfy those distributions. A trust is also great because it avoids probate. Probate, if you go through the will process, is a public process. All your assets, if you go through the probate court, is a public ordeal. And so if you want to maintain some semblance of privacy for your estate and your descendants, you go through trust and it avoids probate. Lastly, it can provide protection for heirs. One thing that can happen when you have a trust, upon your passing, it can turn into what they call irrevocable trust. And so, in practical sense, you fund this trust, it's yours, you can put money in, take money out, you can use it just like a normal investment account. And it's yours, it's accessible. So if you got into an accident, someone could technically, that's the assets held in that revocable trust would be liable to you. However, if you were to pass away and that money went down to your children, it then it will become an irrevocable trust. And what that means is there are protection levers in place to protect anything like, oh, if your child were to end up getting divorced down the road, or if they were to get sued or something like that, the asset is technically not held by your children. It's held by an irrevocable trust for the benefit, the beneficiary, which is your child, right? So again, the trust is to be managed on behalf of a beneficiary. So if you're to pass away and your assets go to an irrevocable trust for the benefit of a beneficiary, your child or your descendant or your loved one technically that's never their account. It's an account for the benefit of them, and that can provide them with a great layer of protection. So I know it's very detailed there, but I want to make sure I covered these bases. The essential elements of a trust, again, are a grantor. That's the person who puts money or makes the deposit or funds the trust. There's the trustee who oversees or administers the trust. Oftentimes, those are the same person while you're alive. The principal is simply the assets that you title into the name of the trust. And a beneficiary is the person who the trust is made for the benefit of. The basic types of trust are living and testamentary. Okay, you can see those right there, that the living is while you're alive, you've created this thing. And testamentary is something that gets turned on and created upon your passing. And so after someone passes away, they can have what's called like a springing trust. A trust gets turned on after they pass away. And then there's revocable and irrevocable. Revocable means you kind of have unfettered access to it throughout your lifetime, and you can make changes to it. An irrevocable trust, once you make deposits or you make gifts into this trust, it's not something you can claw back. It's irrevocable. Okay. Beyond specifying how your assets should be distributed, um, it's really important to understand the end in mind. What are you ultimately hoping to accomplish for your children? Because some people are very pro will and very pro trust, and the reality is, you'll likely have both. You will have a will and a trust simultaneously. But I want to explain just a very simple, because we're getting kind of technical here. I want to explain how a living trust works. Okay. While there are many types of trust, the most common is a revocable living trust. So you look at the bottom of the screen, you'll see basic types of trust. The most common is a revocable living trust. It allows you to transfer ownership of assets from your name to the trust while naming yourself as the trustee, the one who's responsible for overseeing the trust. After you have established the trust, you have the same access and control over your assets as before. You can buy, sell, trade. You can move assets in and out of the trust. and you have the security of knowing your wishes will be carried out if something were to happen to you. After your incapacity or death, the trustee you appointed as your successor assumes control of the trust. They pay taxes, they manage the assets, they make distributions to beneficiaries according to your wishes. So while you're alive, again, a revocable living trust, the most common trust technique, it allows you to transfer assets out of your personal name into the name of a trust. And this will do a number of things. It'll give you control over those assets after you pass away. It'll allow you to avoid probate, and it'll help provide protection for heirs. But all the while you're living, you can do whatever you want with it, just like you would a normal brokerage account. Okay, so we've talked about wills. We've talked about trust. Now we're going to put them side by side. Okay, which is right for you? This is the question we get all the time. Should I get a will or a trust, or a trust or a will? And the answer is often both, right? Because a will, as you can see here, does certain things that a trust does not. A will defines beneficiaries, just like a trust. A will names an executor, okay? A trust doesn't have an executor, it has a trustee, right? And so a will will allow you to name an executor of your estate. A will designates guardians for minor children, but a trust does not do that, okay? A will specifies a court-appointed conservator to manage assets until beneficiaries reach legal age, okay? However, a trust, all right, this is one thing a lot of adults like with minor children like trust, the assets remain in trust until the beneficiaries reach a legal or a designated age, okay? So let's park there for a second. If you have a will-based estate plan, and let's just hypothetically say you have $1 million in personal like investment assets and you have $1 million in life insurance. Upon your and let's say you're a single parent with 2 kids. Upon your passing, okay, um, if you have a will-based estate plan, your minor children will have access to that money. Let's call it $2 million, $1 million apiece. Their percentage of it, we're going to say it's 50-50 at 18 years old. Okay, so their senior year of high school, if you have a will-based estate plan, your minor children could have access to, whatever sum of money that you determine in your will. A trust allows you to have a little bit more control in place and say, hey, I would love to give my kids $2 million, but I know myself at 18, and this is me, for example, I should not have had unfettered access to money like that at 18. So you can either create a trust, like a living trust or a testamentary trust, and you can have it set up to where your kids maybe don't have unfettered access until they hit certain age points. Like I'll candidly tell you, my kids had to hit 2 different age thresholds for our estate plan, and we have a system like this in place for our household. And we like that because we want to make sure we have some levers of control in place to where, maybe they're 25 or 30 or they're 35 or older. You can get as detailed or as broad as you want in those within trust documents, but that's a really important delineation between the two. Okay. Another delineation that you're about to see is with a will, your information is not private. If you pass away with a will, things will go through the probate court system, but that information, your assets that transfer to your estate is public record. Okay. With a trust, if you have everything held in trust or lost anything you have held in trust, actually avoids public record and avoids the probate process. And lastly, there's no protection against conservatorships of the will, but there is a protection like that with a trust. So it's really important. Is a will or a trust better for you? The answer is probably both. A lot of people have a will and a revocable living trust, and they complement each other well. But to say one's better than the other is kind of a fallacy. It's really dependent on what's important to you. And I'd say one of them is better than none of them. We meet a lot of folks and they kind of get paralysis by analysis and they're not sure they want a will or trust. And I'll tell them point blank, just get something. Even if it's a very, very simple will or a very inexpensive will, just get something on paper first. And then we can always circle back and make amendments or changes after the fact. Another document that's very important in an estate plan that sometimes gets overlooked are powers of attorney. Okay. There are several types of powers of attorney that can authorize someone to act on your behalf. But a power of attorney, in its simplest form, is the authority you give someone to act and make decisions on your behalf while you are alive. Now, note, you also see this expression durable power of attorney. A durable power of attorney remains in effect even if you are incapacitated. Okay. So if you are in a coma or you're on life support, something like that, a durable power of attorney kicks into gear when that happens. So, like I said, there's several types of power of attorneys. Okay. But let me kind of go over those as you can see on the screen. A financial power of attorney is someone who can oversee your bank or brokerage or investment related assets. A medical power of attorney is someone you trust to make medical decisions on your behalf. They're two separate legal documents. Medical directives, not necessarily a power of attorney. These allow you to state what type of medical treatment you do or do not wish to receive if you're too ill to direct your own care. This is essentially a do not resuscitate order. This is where some people, you know, if they choose to, be put on life support or not life support, that falls in the medical directives camp. And lastly, HIPAA authorization. This is a document you sign to give permission to third parties to share your medical information. This is a very, very important document that we cannot stress enough to clients with adult children. So once your child turns 18, we want to, without a shadow of a doubt, make sure in addition to your estate plan, you have a HIPAA authorization form. Because the second your 18-year-old goes off to college, if they get into an accident or something happens to them, as an adult, as an 18-year-old, the hospital is not required or permitted to give you any information about your child, okay? And so having a HIPAA authorization form allows you to get that information from a third party should you be able to need consent or something like that for your adult children. So like we said here, there are several types of power of attorneys that can authorize someone to act on your behalf, but a power of attorney can be written to take effect now or activate if you are no longer able to make decisions on your own. A durable power of attorney is one that takes effect once it's signed, but all of these things, power of attorneys, just to be clear, they terminate or they expire at your death or your passing. Okay, the last slide, which includes documents to consider. These are documents that don't get enough, I don't know, I don't think they get enough attention, but they're a huge integral part of an estate plan. Advanced directives, okay? This one informs your loved ones of your prearranged medical decisions if you are unable to communicate. Okay, so we talked about medical directives. I mean, these are the same thing. So advanced directives, medical directives, they essentially allow you to make decisions so your loved ones don't have to. And we love estate planning. I personally love estate planning, but one of the unfortunate realities of estate planning is walking through tough times with clients. And I can tell you, having clients pass away or maybe have their parents pass away, the last thing you want to do is put your child or your loved one in a position to have to make that decision themselves. Having an advanced directive or a medical directive in place kind of separates them from that and allows them to just respect your wishes. And so it's a huge, huge blessing to give a loved one is to have that form filled out in advance if something were to happen to you. The next item on here is a love letter to family. This is something, again, I don't think gets enough attention, but it's a huge, indispensable planning tool that allows you to kind of contextualize or take your estate plan to the next level. And what I mean by that is it bridges the gap between all these documents, all this legalese, into a letter that you sit down and written to your loved ones. It allows you to explain why you made the decisions you made or how you made the decisions. And really, it's a great resource to have sitting on top of your estate plan, which is normally kind of a packet of paperwork or a bundle of paperwork, just to give to your executor or your loved ones after you pass away. It's kind of, I mean, it's a love letter to your family, and so you can make it what you want, but really, it's a great document that allows you just to say, hey, here are my ultimate wishes. It's going to be carried out through all these legal documents, but I want you to hear in my voice and my tone and what means to me and why I have chosen to execute my estate plan in this fashion. Lastly, this has become very popular, not popular, but important in the last couple of years, having a digital estate plan, okay? In addition to bank accounts and investment accounts, almost all of us have a smartphone with something like Google Photos or iCloud or things like that. And so making a list of your digital accounts can greatly help your loved ones as you protect your memories as well as your estate and identity after you pass away. So make sure with this you're thorough with your inventory and include as many of these digital assets as possible. Social media accounts, email information, banking information, subscription services. These are all things that, I mean, they're part of our everyday lives, but we forget to kind of figure out, if I were to pass away, would my loved one know how to access my social media pages or my emails, or heck, just access my phone so they could see photos? It's something that gets overlooked, but it's very important to think about that as you develop an estate plan. Next, we're going to talk about, as we alluded to earlier, common mistakes to avoid. These are mistakes that we see quite often among clients, and I just want to make sure we shed a little bit of time on mistakes that come up quite a bit for us. The first and the easiest one, not having a will or an estate plan. No decision is still a decision. And so if you choose to not have an estate plan, that is a conscious choice you're making as well, and one that you're making for your loved ones. And you may not have kids. You may be single and doing well, but regardless, if something were to happen to you and you have any assets whatsoever, your family's going to have to go through the probate process. And so having a will, regardless of where you're at in your life stage, is incredibly valuable. The second is not reviewing documents and beneficiary designations after a major life change. I was talking with a client just this morning about this. They had a third child and said, all right, let's go ahead and clean up those contingent beneficiaries, because the way theirs is set up, they have, they call it like a sweetheart estate plan where his wife is the primary on everything of his and he's the primary on everything of hers, but they have their three children listed out as equal beneficiaries. Well, I don't know how that third child would feel, but if you only kept two of your three kids as beneficiaries on your accounts, that could lead to some awkward conversation somewhere down the road. So just making sure that's cleaned up every couple of years. If you're a business owner, not having a succession plan for your business is hugely important to your loved ones. I mean, you've probably worked so hard to get your business up and running. You have to ask yourself, if you were to pass away, what would happen to your business? What would happen to your loved ones or your employees, right? How dependent on that business is your family for cash flow? Okay. What would happen to your customers or your clients? I think for business owners, it's incredibly important to think about your estate plan and have contingency measures in place to where if you were to pass away, a succession plan is laid out in advance. And that's just one less thing for your family to have to think about upon your passing. Failing to complete your entire estate plan, including ancillary documents. This is so common. We hear clients all the time. Yes, I have an estate plan. I have a will. Okay, that's not an estate plan. That's a will. So what I'd suggest here, if you don't have one already, your estate plan should include a will and or trust, a will or trust, advanced directives, powers of attorney, things of that nature. It's the whole swath of things that we talked about a while ago. The second to last thing, failing to communicate your wishes, both verbally and in writing. There are certain folks you meet with, and they've worked so hard for so long, and they've chosen to be very private with their wealth, even from their own kids or their loved ones, and that's their right. But what I'd say to them is they're thinking about their estate plan is it's really important if you're not going to tell your beneficiaries or loved ones, at least have a clear line of communication between yourself and your executor. Okay, we've talked about that love letter to family. In addition to that, making sure your executor really knows your wishes and is updated where your assets are held and how things are structured. Because to be candid, when someone passes away, all this grief and trauma just comes flooding in. And what you have in an estate plan is a guidebook and a roadmap for them to follow. So it takes the emotion out of it. They're not having to make decisions. You made them for them. And that's a very powerful gift to give to your loved ones. And lastly, for those who have trust, titling or funding the trust. One of my friends is an estate planning attorney, and he said, I'd be shocked at how much money is spent every year on revocable living trusts that never get funded. You can create this amazing trust and this amazing estate planning vehicle, but if you never put anything inside the trust or you never fund the trust or title it, it's just kind of a waste of money. And so what we'd suggest is if you've developed a trust, please make sure to retitle your accounts, your investment accounts, your house, things like that. Those are types of assets we'd want to make sure are held in trust or business interests as well. Okay. The next slide here, we touched on the very beginning, are some considerations with estate planning for various folks. It's really, you don't want to make generalizations with estate planning because it's such an intimate, personal thing for every family. But I will say at large, these I've written out 5 different kind of groups of or things to consider with estate planning. If you have a blended family, so you've remarried and you have stepchildren, um, you need to be very intentional about crafting your estate plan because a lot of issues can arise about equity and what happens if something happens to you. Does it go to your stepwife or your stepspouse, or does it go to your children, or how are the stepchildren treated in your estate plan? That's something to consider. If you have disabled dependents, if you have a child who is disabled or unable to live independently or just take over basic money management skills, you need to discuss this with an estate planning attorney because there are additional steps that you can take to protect your child down the road. For those who have children who are fully disabled, there's a lot of government resources and support available to those folks if you use certain estate planning techniques. And so we want to make sure if that's you and you fall in that camp that you address that with a proper board certified estate planning attorney. If you own a business, you have to ask, do you or your partners have a clearly defined succession plan? And what measures are in place to continue operating your business if you were to pass away? And if not, what impact could this have on your loved ones or your customers? If the large swath of your net worth is tied up in this business and something happens to you, what does that do to your loved ones who are left behind? And if you have partners or employees or key employees who've been there for a long time, what does that do to their families? And so making sure you think about your business in relation to your estate plan is largely valuable. A lot of folks think, I'm just going to pass it on to my kids. And this kind of goes with the family owned property thing. But I meet so many folks who say, I'm going to give it to my son or my daughter or my loved ones without thinking, does their son or daughter or loved ones want that asset? We find this sometimes with family-owned property, which is the next point. Let's say you're leaving behind a chunk of land or a farm or something like that to your loved ones. I think your intentions may be pure, but you have to ask yourself, do my kids want this? And if they do want it, have we considered their ability to maintain the property, both physically and financially? Let's say you pass away in your 80s and your kids are in their 50s. They're working really hard. That's kind of their peak earning years. So maybe they're busy and they've got kids too. Have you considered how what can be considered a gift or a blessing could end up being a burden of responsibility that they may or may not want to shoulder? And the only way to kind of figure that out is to have open lines of communication between yourselves and your loved ones. And lastly, the larger your estate, the more critical it is to minimize your tax liability. Right now, you have to have a sizable net worth to have what's called a taxable estate. We're talking, over 24, $25 million for a household. But come 2026, the IRS tax code is going to revert, and they're going to it's called sunset. And we're going to go back to a very much low, a much lower estate tax exemption to where folks with an individual estate gift limit would be around 5.5 million, and it could go upwards of 11 million for a married couple, which is as much a different number than someone with maybe 24, 25 million. Okay, so these are some considerations. If you have a blended family, disabled children, or business ownership or family-owned property that may be a burden of responsibility for those behind. So we've covered a lot today. So go all the way back to the beginning. Okay, we've mulled over these questions. Does everything go to your spouse or your loved ones? Do you have the right beneficiaries in place? If you're out of it, who's going to call the shots? And you can see these questions here. We've talked about what exactly is an estate plan, right? There's essentials for everyone. Everyone should have a will, a power of attorney, advanced directives, and proper beneficiaries. If you have a young family or maybe business owner, you may need life insurance. You can kind of go through this list here. We've talked about where your assets go, whether it's a loved one or by beneficiary designation or held in trust, and then the rest goes through probate. We've talked about asset titling and wills and what is a will and what is a trust. We talked about maybe comparing what's better or worse or a combination of both. We talked about powers of attorney and other documents that go into an estate plan. We've also talked about mistakes you can avoid and considerations to maybe have if you have a blended family or some other specific circumstances that kind of fall outside the norm. So where do you go from here? Okay, we've learned all this, and the whole crux of this webinar today was about kind of planning and getting ahead of the holidays. This might be a time of year where you're sitting down at Thanksgiving with your loved ones or Christmas, and this may be the only time you see them this year. So having this conversation is really important, and doing so with some sensitivity is important too, because this is a very delicate matter. We take a great deal of pride in what we do at Aspen, but it's not lost on us that we have a very important job given the intimate nature we have with our clients. And what I mean by that is when you sit down at Thanksgiving, you can talk about football, you can talk about politics, heck, you might talk about religion, but I would be hard pressed to say that you pull out your phone and show your cousin your bank account. Okay. That's the gravity that I think we should take as financial planners in knowing that this is a very heavy responsibility. And I think you can get a little bit of a glimpse of that when you talk about your money and your finances with your loved ones as it relates to your estate plan. So where do you go from here? Well, step one, take inventory. You need to list your assets, your debts, and other relevant details on a single document. Some people call this like a personal financial statement or just a net worth statement, but just take inventory of what you have, okay? Step two, create a plan. Once you've established what you have, okay, then you can determine what your goals are. You can establish your needs and goals and prepare to meet with an estate planning attorney or use an online service like a trust and will. But during this creating a plan process, I want you to really think about some key areas. If you have children, who do you want to name as your guardian? Who do you want, regardless, to name as your beneficiaries? Okay. Like we talked about earlier, some people, they don't have kids, and that's okay. It almost can become harder. It's like, do you name nieces and nephews or siblings or 501c3 charitable organizations? But you need to have beneficiaries on your account. Who do you want to name as your powers of attorney, both medical and financial? Who would you want to name as your executor? And for a moment, I want to pause there and think about the weight and the gravity of what the executor's role is in an estate plan. It's a lot of responsibility. Okay, so before you just flippantly name an executor, I'd encourage you to have a conversation with that individual and explain through what does being an executor look like? What are the responsibilities? And if they're up for that task, great. But I wouldn't just flippantly put a name down on a sheet of paper and without talking to that person first to make sure they can shoulder that responsibility. And the same goes for guardians. No one, I mean, like for example, I've got siblings and my wife has siblings, and we don't want anyone to be surprised upon our passing that they became a guardian overnight. So make sure you have that conversation in advance. And if you have a trust, who do you want to name as your trustee or your successor trustees? Okay. The third step, as you see here, is very simple. Put your plan into action. This is where a lot of people kind of get stuck in step two, creating a plan, because they get that paralysis by analysis. But step three is putting it into action. Once you've formed your estate plan, either through a service like Trust and Will or an estate planning attorney, title your assets into the proper form of ownership, particularly assets that you and your attorney have identified to your trust. Make appropriate beneficiary designations. Provide for asset management if needed. And lastly, update your plan regularly. Review and update your documents and accounts as life events or changes occur. Laws change, family dynamics change, families change, okay? And so just like a financial plan, it's a fluid, living, breathing document. I think your estate plan should be as well. And I apologize. On this slide here, you'll see that Candace, my colleague, was going to be on this call today, but she had another engagement she had to attend. So my colleague Troy is on this call. So I'll make sure everyone has his email information after the fact. Okay. So at this point in time, we're going to stop and answer questions. We've covered a lot today. So I'm going to stop for a second and let you guys kind of mull over this information. We've been using the chat feature throughout this presentation. So if you have any questions, please feel free to put them here. And I'll be happy to answer those for you as they come along. And I'm going to let Troy kind of facilitate that because while I've been presenting, I haven't been able to kind of sift through and field questions. Troy, are you there?
Yeah, not seeing any questions coming through the chat just yet, but we can cover some of the common questions we got if no one has any on the call.
All right. I know we got some via email earlier today. I guess we can address those, and I know this will be reposted on YouTube and for others to watch at another time. So what questions were some of those that came through?
Just what is probate? You covered it, Jim, a lot of these details, but I can just kind of emphasize your points earlier. So probate is the process by which the will is validated by the court and the executor is actually appointed. Until letters testamentary are issued by a court as part of the probate process, the executor named in the will has no authority to handle the deceased person's property. So your attorney can guide you through that probate process, but something we see a lot, contrary to popular belief, a will is not effective just because it's signed. A will sets forth a testator's intent. So if it's your will, you're the testator, but that intent cannot be carried out until the will is recognized as valid by a court. So that was one of the questions. Another question.
And that's a good point, real quick on that. Like a lot of
Yeah,
folks in Texas, a will has to be witnessed and notarized. And so a lot of
right.
people will draft a will, they'll draft it, and it can be a great will, but if it's not witnessed and notarized, then it can, depending on the more often than not, it's seen as kind of an illegitimate document or an invalid document. And so that's something that can be a big surprise to folks. And so if you have a will or a will-based estate plan, make sure you get that signed and notarized. That's to make it a legally binding document.
Yeah. Another question we got is, when should we start our estate plan and do we need one? What about our kids? So you made this point earlier too, Jim, but for the reasons you mentioned, everyone needs one, long story short. For your kids, that really depends based on conservatorship and guardianship, and that's set up in wills and trusts. But once they turn 18, your 18-year-old adult children should have documents appointing agents for medical and financial decisions if he or she were to become incapacitated, and should also think about his or her bank accounts, car, a beneficiary designation be all that 18-year-old might need. But as people acquire more assets, especially when they buy homes or become the beneficiary of a trust, they'll need more detailed planning. When you have a child, you need to have the hard conversation about who would be a proper guardian for your child, like Jim mentioned earlier. If you were to pass away, and how would you want your estate administered for that child?
Yeah, that's true. All those things are true. Yeah, I mean, everyone needs one. And there's the fallacy is I don't have any kids, I don't have a lot of stuff. If you pass away, something's going through probate, and so
Right.
you
Yeah.
really want it. If it only takes a few minutes to get one done, I think it's worth getting time. Carl, I saw your question here. Have you seen any problems with life insurance payouts? I mean, candidly, no. But I'll explain to you why. Yeah, I should say yes and no. Um, this is how life insurance gets paid out. In this second box right here, the beneficiary designation. Okay. So if you have a beneficiary tied to it, in practical terms, what happens is, like Troy said, you go through the probate process, you get named, and so you present. It kind of avoids probate. So if you have what you still need is a death certificate. So let's say something happens to a loved one. You take that death certificate, and let's say you're the sole beneficiary. You go to John Hancock or Pacific Life or one of these life insurance companies, and you provide your identification and you provide the death certificate, and those things line up and that they pay them out. The problem lies if you don't have a beneficiary name on the account, then that asset will go through the probate process. And so, or the life insurance proceeds will go through the probate process. And so that payout, unless specified through a beneficiary designation, will go through payout. There's a second wrinkle to that. I mean, I can't really have this on my estate plan. You can name in your estate plan if you're okay with the probate process, because some states aren't that complicated. We don't want to make probate sound like the worst thing in the world. In Texas, it can be a very efficient process, but you could have maybe your beneficiary or contingent beneficiary, like or a trust, or you can even go so far as to say the last will and testament of Carl X. And so you can name your will and testament, or you can name your trust as a beneficiary, and so it flows through that way. But if you just name it outright, it's a very simple and clean process. The issue is if nothing is on there, if no beneficiary is on there, you're going to have some difficulties. And I mean, it's just it'll likely get solved, but we just seen enough bad examples from personal experiences where You just don't want to have to get that contested in court. And it creates an unnecessary problem if it's not properly addressed. And the easiest way to do that is just slap a beneficiary in the account and it should be totally fine. And if your beneficiaries get married, if your beneficiaries, let's say you have a son or daughter and they're a beneficiary and they get married and they change their name, and that could be something to think about as well. And so I'd say as a whole, life insurance is very clean and simple. If you have the beneficiaries properly tuned up, then you don't have to worry about it. But nevertheless, there's enough, little things that could slip up to make sure that doesn't get rectified or answered properly. I hope that answers your question.
Right. Yeah. And reviewing your beneficiaries every couple of years and as life changes, reviewing those, making sure you have contingent beneficiaries. A lot of people only have primaries. So if something happens to them, just making sure there's someone second in line. But yeah, Jim, that's spot on.
Awesome. All right, guys. Well, thank you so much for taking the time. Again, my name is Jim Davis. I'm one of the senior wealth planners here at Aspen Wealth Management. This is going to be available as a recording through YouTube. If you know anyone who could benefit from just learning more about estate planning, or if you just want to listen to this on your drive to go have Thanksgiving meal with your fans and family, feel free to pass this along. But we hope this is helpful for you today and for your loved ones as well. If you have any questions about your estate plan, or you just want someone to kind of take a second look at your estate plan, please give us a shout. We're happy to do that for you guys, and would be very glad to kind of look over those documents with you and your family. So thank you again. Our contact information was at the last slide, but you'll have an email with us coming after this. So if you need anything, just give us a shout. We appreciate y'all very much for attending today.
Thanks, everyone.